to our last main session. So GDPR 2025, GDPR 2030, what we are going to be discussing in a few years. So it's time to welcome our moderator, Ms. Lokke Moerel, and our four distinguished speakers, no particular order, Mr. Axel Voss, Ms. Anna Fielder, Mr. Michael Veale, and Mr. Matthew Newman. Ms. Moerel, as the moderator, we'll leave it to you to lead the dance for the next hour.
Thank you. Well, what a diehard. Wojciech already wrapped up the conference in, I think, of a very successful conference in a perfect way. And he gave me free rein to discuss after he spoke. Let's see whether he will do it again. So, enforcement 2025-30. Well, Mark Zuckerberg promised us the metaverse in 2025, so a whole new universe to think about. And I think a perfect metaphor what this panel is about. I see some people, including DPAs, actually being quite complacent that GDPR will be future-proof, that we have a flexible, open norm and system that can weather the storm, and that we don't need to revisit the basics. Well, let's see whether we agree in this panel. We had an honest look in this conference, and I applaud the EDPS for organizing that, at the mechanics of the enforcement, the incremental improvements, and we heard Wojciech proposing some improvements, which I very much applaud. And I want to say up front, I know there are bottlenecks in enforcement and hiccups in cooperation, but my assessment after all these years is that the DPAs really try. They make a very good effort, that is true. And when they sometimes defend themselves, like, look what we all do, it sounds defensive, but actually I think they're doing their best in difficult circumstances. But yes, things can and should be improved. But the main message of this panel, because we prepared, is that we think we better get our house in order. We need to make it work because things will get exponentially worse. Or better, no, worse, I think, depending on how you look at it. We will have 5G with exponential data processing. The EU is getting up to speed with all the new DMA, DSA, I'm not going to list them, most people did that today. And each and every one of them has a total crossover with data protection. There will be so many new issues to be dealt with, and we're not yet on top of the initial digital ecosystem and the business models that power that. So, second, the GDPR enforcement system is taken as a template for many of the other laws. And if we have teething problems, they already contain some improvements. But I think if we have teething problems in cooperation, we need to solve them before we duplicate them for the others. But also, we export GDPR, the Brussels effect. The good and the bad. So maybe noblesse oblige, we should get the enforcement right as well. The EDPB and EDPS have proposed that the DPAs will be the enforcement agencies, the supervisory authorities for the Data Act as well. In the Netherlands and Spain, we see the DPAs likely being appointed as the algorithm supervisor. I think we need to get our house in order before we give them additional hats, because I think we're setting them up to fail. So, difficult times ahead. An excellent panel to discuss this with. I know they have a lot of thinking power into these topics. Axel Voss, he doesn't need an introduction, as all people here. He's the Member of Parliament, and he has been involved in all data protection and AI files that ever were there. Michael Veale, maybe Associate Professor Digital Right and Regulation at UCL, and also sometimes if nobody listens to him, an activist. Anna Veale, president of the European Digital Rights, also EDRI. So also no introduction required. And Matthew Newman, he's the chief correspondent, data protection of Mlex. But more interesting, I think, he was the press officer of the European Commission when GDPR was proposed, and he has a very good memory. So the question for the panel today is, look, let's have utopia. All the things are done that Wojciech said. We have enough budget and capacity. We have a one-stop shop that works. They work together with the other authorities, maybe even on a global level. Do we then feel comfortable? Panel, do we feel comfortable? Or what is your first reaction? Anna, can I start with you?
Thank you very much. Can you hear me?
Absolutely.
This chair is so comfortable. I just feel like, you know, hot weather, everybody wants to go back to the beach. So, you know, we'll try to be...
We'll bear with you.
Yeah, bear with me. First of all, I want to extend a heartfelt thanks to the EDPS for organizing this conference, and in particular for including so much civil society in it. I was actually, and Axel will probably remember, we had a lot of discussions when GDPR was passing through the European Parliament. I was one of the cohort of a handful of NGOs that campaigned very, very strongly for GDPR. So it is a very dear regulation to us and needs to be made sure to be enforced effectively. So I treat it as a preschool child, still to be educated and the culture to be developed, certainly not to be amputated or made disease in any way. I have one general observation and a recommendation to the EDPS, and that was because I heard so much good stuff from so many clever people in this conference, but only my colleagues in the civil society talked about the other side of the coin, which actually the people that are affected. So maybe the next conference that EDPS will organize will be a citizen forum where they will call some real people to talk about their experience and what they feel about how their rights, fundamental rights, are affected, because we need to hear from them as well. We haven't heard enough from them, except from my colleagues. And what you need to remember is that these people are not technologically savvy. They don't know what's happening under the bonnet. They're not necessarily rational and logical the way our Max Schremm is. So giving them information is not enough. They have to be defended in a very proactive, realistic way. And the second thing that you need to remember is that, and some of my colleagues said this as well, that the impacts are on communities, not necessarily and only on individuals. And when we talk about privacy of communities, we talk a lot about children, and we have methods to defend them, including in the US, incidentally, but we don't necessarily talk about disabled people or immigrant communities or LGBT communities that are actually some of the most affected by lack of privacy rules. So I have two general proposals. One was already mentioned in the first panel, and it's integrated enforcement. In other words, DPAs and authorities, please work together with third parties, NGOs in particular, that are really willing to do investigations, point out to you what the deficiencies are, and embrace collective redress, because that is a partner to enforcement. It's not a turf war, it's a partnership. And we have a directive coming into effect next June. That's a great step in the right direction. I hope by 2030 we'll have proper class action. Because if you remember the Dieselgate scandal, it's the countries that have by law in their legislation class action that had the most effective remedies, including the US incidentally. And my second general proposal, we have a legislation coming up, Artificial Intelligence Act. It is one opportunity to address and add to effective enforcement, because this act at the moment does not empower people affected to get effective remedy. Yeah. In particular, it doesn't foresee any private enforcement, and it is not mentioned in the Representative Action Directive.
Thank you.
So,
yeah, great point. And I'm sure Axel will react.
I'm sure he will, yeah.
No, I'm curious because I noted it too. Matthew, can you give a...
Absolutely, yes. Yes, I'd like to thank the organizers as well. And it's a pleasure being on the panel. Yes, I was, just in terms of full disclosure, I was a spokesman at the European Commission, and that was 10 years ago. Oh. So there's enough space between then and now. But I will let you in on one secret about the negotiations that happened back then. It was the most heavily lobbied piece of legislation that I'd ever seen in my life. So we were bombarded with requests, and I'm sure Mr. Voss knows all about that because he was then bombarded with lobbying. So Pandora's box, as Wojciech said this morning, if we open it up, or I'm sorry, that was Commissioner Ranger said that if we open it up again, that would be a Pandora's box if we did that. So. Just in terms of what I do now, I'm more used to asking questions rather than answering them. But I just would make one short remark, and that's to follow up on what I heard yesterday and just even right now. And it's about the credibility of the EU institutions and the credibility of the GDPR in itself. I think there's a real risk that if there isn't effective enforcement, that normal people will lose all faith in the GDPR. And the reason I say that is because normal people hate the GDPR. They really do. Like, they hate all the requirements, the burdens, and this hatred comes from this feeling that why us? Why are we subjected to all these rules and regulations? I'm talking about like small businesses, and the big players seemingly are getting off scot-free. So that is a huge challenge, I think, a disconnect. We heard a lot about that in the last couple of days, but we really need to address that. So I think in the future, if we're looking in 2025, 2030, if the EU institutions haven't tackled that, we are in for serious trouble.
Serious trouble. Off the cuff, your first reaction, or one point.
Yeah, so I think one trend that is really going to be crucial over the next few years, we've seen the history of data protection also since the 1970s, tackling big data banks. You know, now we've got data giants. This is not going to be the biggest problem in the future. The biggest problem, we're moving from data giants to infrastructural giants. And that's a very different challenge. Data protection was not easily set up to regulate. So even if we have our utopia of lots of perfect cooperation and capacity and so on, I think this will be a challenge. And why is that? Well, in a way, data protection has been very successful. We're already seeing this. We're seeing that many companies who are controlling large computing infrastructures, smartphones, computers, are saying, hey, we can do more with less. We can collect less data because now we control the code on devices. So we can make devices compute together privately, confidentially, have our cake and eat it. We can do cool things like link data between hospitals. The data actually never moves, but we get the results almost out of thin air. Multi-party computation, homomorphic encryption, confidential computing, lots of really cool technologies. However, there's a bit of a dark side to this. The dark side is that just because something's confidential doesn't mean it's ethical. We start to see processing on devices, on smartphones, in smartphone ecosystems, on PCs, also in smart environments, that can be capturing populations, hyper-personalizing them, processing in unfair ways, effectively trapping them in informational environments, wielding informational power. But companies can say, oh, it's all confidential.
And privacy
it's all,
by design.
Yeah, privacy by design, that's what you asked for, isn't it?
Yeah.
And to tackle this is tricky, because there are a few reasons for this. One of them is that it requires data protection authorities. They can't just knock on the door of who has the data. Start to say, who's setting the rules? Who's setting the rules in concert around the world? Ecosystems, we found, are very hard to regulate for DPAs. The enforcement units of DPAs quite like data breaches. You can find where it came from, knock on the door. So you see DPAs quite willing to enforce that. You find it a lot harder there to change fundamental rules. We find, say, in the advertising ecosystem, it's very hard to pin down entities that are setting the rules, pin down liability, responsibility, because they are designed to spread it around, make it quite nebulous and slippery. And one last example I'd just kind of put out there that may be a challenge. So let's imagine we have a browser, Google Chrome would be one of them, and this browser is collecting all your web history. Maybe it's linking to your Fitbit, competition, case reference, and other things, looking at your eye gaze, heart rate. It's personalizing things to you. It's giving you information, changing your world, targeting advertising, whatever you want to do. Not just that, but actually delivering services, engaging in economic activity, virtual environments, and this feels quite unfair. This feels like it's really infringing on your autonomy, but it's very hard to say no to. These are, I think, the challenges we have to reckon with, and which will be hard for data protection authorities to do. And this means our metaphors fail. Data flows, accumulating data, all these things. Data isn't flowing.
No.
Computation is being orchestrated. So how are DPAs going to deal with orchestration power in the future?
Well, let's go to AI. No. Axel, your point.
So you all mentioned my favorite subject.
Exactly.
Data protection.
Yes.
That's why you're here. That's why you're here.
So at first, of course, I would like also to thank the organizer, Wojciech, thanks for the invitation. And so my first recommendation would be do this yearly, because we have a kind of a changing the world every year or every month or whatever, so it's necessary to talk about these digital or data issues. But also please invite all those people who are dealing with these in their business models. So this is necessary to get also aware, or to be aware what their problems are with the data protection regulation. So this would be my first recommendation. The second one is, we are living not alone on this world. We are in a global competition, and data, in a data-driven world, plays a central role. And if we are just intending to go to this direction and say, oh, no, we shouldn't process any data at all, and we created a mentality with the GDPR where we are saying, do not process personal data unless blah, blah, blah. And this mentality now, it seems to me, will be circumvented by the Data Governance Act, by the Data Act, because we have to change this mentality if we would like to still have a kind of a proper future and so on. So, and here we have to ask ourselves how we will survive in this global competition as a EU on this digital level. And data protection will not buy my bread at the end, so we have to think about how we can balance data protection or other privacy protection issues to the competition. Sorry, to the competition. And here, and this is my point, there are privacy tech in place, but we are not open-minded enough to use it, to be more innovative. And also to try to get a kind of a leading position in, let's say, one area at least. And that's why I think we have to change. And just saying opening the GDPR is opening like the Pandora box, this is totally wrong thinking in a totally dynamic world. So, of course, we can sit here and say, oh yes, this is our gold standard, 2018, but if we are not training them, if we are not updating this, then this is getting pretty much old, and we are sitting there and saying, oh, but we have our principles from the last century, and we are living fine with it. No, the best point would be open, try to balance, use privacy technology in balancing this better, and then we might come forward. And let me do this last point. Europe has or can provide to the world a lot if we are combining values, fundamental rights to technology. And this can be done, but we have to be as speedy as the other regions in the world.
We need to innovate
and we need to be flexible.
Yeah.
And therefore also working on a GDPR, and this has different levels how we can do this.
Yeah.
But working on the GDPR doesn't mean we do not want data protection. It means we would like to survive in the digital age in the future.
I think it's very true, and we are going to go into more depth on, in each of the topics you mentioned. Can I have the first slide? Yeah, I hope you can laugh. I used this picture in 2014, well before GDPR. Because already at that time, how many years ago is it? I thought there was so much going on, I thought people didn't get what was going on. And I thought giving more strict requirements on consent and notice will just worsen the problem rather than solve it, and that we should have a discussion about what the material rules should be, not whether there's consent, whether it's legitimate, it's correct, legal from a legal perspective, but whether the processing itself is legitimate. And I bring this up because it is what we've seen in all the enforcement. If you have procedural rules, what do you need to get valid consent, the information, etc. You get procedural enforcement. It's about, is the consent validly given? Is the information given? Is a pre-tick box? That was my total deep point that I went to the European Court. Whether a pre-tick box was valid consent. All your collective enforcement efforts focused on procedure instead of trying to discuss what a fair society should look like. We should have a discussion what is not what is legal, but what is legitimate. So I think data protection needs to regain its role as a material. The material rules, what are allowed and not allowed, for the reason that we can have enforcement on the material rules, and they may well be easier to enforce. And what I want to bring up is that Lina Khan, the new chair, and I don't have my glasses on, so I can't read it on the screen there, but she basically says that the notice and consent paradigm is outdated, that there are no real alternatives for individuals, and that we should consider the substantive limits rather than the procedural protections, which tend to create process requirements while sidestepping the fundamental questions. I agree. What I'm worried about, no, I would like the FTC being a very strong privacy enforcer. But you know, what I'm worried about is that with all our efforts, they may become far more efficient than we. And that is what I would hate. I'm not competitive, but I wouldn't like that. So, Anna, I know you have views on this as well, so maybe you can kick it off with
yes,
some
certainly.
thoughts.
I'm not going to comment extensively on the FTC because I happen to know a lot about the US situation, and the issue with FTC is that they have limited powers. You know, what they can regulate effectively, but under one
provision.
What I wanted to say is that, you know, look at examples where you have from other legislations like consumer protection, like health and safety, where you actually regulate ex ante the harms that can happen. So, you know, think of cars or unsafe as any speed. You tell people they have to put safety belts on because if the car breaks down, you know, you don't want them to be hurt. We don't do that in data protection privacy legislation. We have cookies and we have to read what they mean and say yes or no. So maybe what we should do is actually say ban certain practices from happening, ban targeted advertising, ban biometric surveillance in public places, you know, very simple. So then you have all this ecosystem that Michael described. They have to conform to that ban and not do it and devise other business model, which incidentally will generate innovation and competition as well. And we're going in the right direction in the discussion on the Artificial Intelligence Act.
I would want to leave that to Axel.
Yeah.
Axel, can you?
But not enough.
Yeah.
Not enough.
No.
Needs to be stronger, needs to address future harms, and needs to have fundamental rights impacts. So it's a step in the right direction, but Axel, I hope you go further.
Yeah. This is the invitation to you, Axel.
Yes. Let me summarize this a little bit regarding AI. So what I would have in mind is, yes, we are coming with our fundamental rights and with a long list of ethical principles and in general principles, what should AI algorithms deliver? So this is, and Anna, I would say here we are on a good way. But if you're approaching these only from a consumer right angle, then we are out of the business. And this is happening in the European Parliament. So far I can say this, so we are not very far ahead. So this would create, if we are sticking to this product regulation, then we might have this all in place, but overloading these with consumer rights protection issues, what we have already 50 times in other laws, it doesn't make sense. But again, we are coming here to a situation where we have this long wish list, and what the outcome of an AI system should be. But if we are not delivering the quality data to train these algorithms, then we can't fulfill this AI Act at the end. So meaning, if we do not want these non-biased, non-discriminatory, and gender-balanced, and so on, you will need personal data to train your algorithms on these, if this should be quality.
Even sensitive categories to check whether the bias is in. It's one of this.
If we are coming to the health market, there are sensitive data all over. But if we would like to be a part of this €1 trillion market of whatever it is in English after trillion,
gazillion.
Then we are out of the business. If we are not daring to collect these sensitive data and giving these a chance to analyze for new methods, new products, new treatments or whatever, then we are out. We are dependent on other competition regions. And this is what I'm fearing a little bit, that we are too restrictive. And there are ways to balance.
Do it in a responsible way.
Yes.
Yeah. You want to go?
Yeah, that would be great. A couple of points. One of them, I didn't want to talk about the AI Act too much here. I want to say that I think the AI Act is ridiculous. The AI is not a product, basically. The Commission has reached for a tool that it created in the 1970s onwards, and that tool relies on the manufacturer or the provider being able to effectively assess, being the best placed organizational person to assess risks, safety, and so on. However, in AI, the provider in the AI Act neither can look upstream, which is entirely dominated by general-purpose models, infrastructures like I was talking before, not personal data. There's no plucky European SME putting data together, making the continent's best AI system. They are trapped in infrastructural webs that expand across jurisdictions and are increasingly using less and less personal data and more infrastructure.
So, positive.
Yeah, wait, two seconds.
No,
yeah, go.
To the future.
I am going to the future. Yeah.
Enforcement.
Yeah, so I think we have to move away from, we have to be more creative with, and product safety standards, product safety approaches are incorrect. And yeah, I want to say that about there. On this consent issue, notice and consent and so on, we have a similar misunderstanding. And this is going to be a problem that's going to create enforcement issues we have to get ahead of, like the topic of this called conference. So with consent, take ad tech, cookie banners, what we've talked about here. This was not a product of the GDPR. This was created by industry. This was a concept that said, how do we turn consent, which is a residual category in data protection law, when nothing else works, you still have the liberal ability to say, okay, this isn't prohibited, people can still say yes to things, like they still have the freedom to do what they want with data that relates to them. This residual category was turned into something where, in our study, the average click yes button to a cookie banner sends data to 315 vendors. It is impossible for an individual to consent to this number of people, as the Belgian DPA pointed out recently in a ruling. This is not valid consent. This is industry interpretation of law, new law, being put into place before enforcement can happen, creating a Jenga tower which regulators and DPAs have to knock down later if they want to do enforcement. So, what do we do to fix this? Get ahead of the curve. We cannot let, whether it's for metaverse or blockchain or whatever word you want to throw out there, we cannot let the incumbent actors define what compliance looks like. Because if they do that, it will mean that regulators are faced with the impossible task of down the road saying, you're going to destroy this market. You told us it was compliant, or at least you didn't do anything about it during the first 3 years.
I think this is a great... Next. This is Mark Zuckerberg on the metaverse, and I'll give you a second to read it. This is building on your point, totally. And Zuckerberg is totally right. This is privacy and ethics by design. But the real issue is that the design of a new world is now in the hands not only of one company, it's in the whole network, a whole new ecosystem of companies that work together and do all types of things.
And we know who writes open standards. Google.
Exactly. No, but I mean, so I think by now, like Zuckerberg, we had the first digital ecosystem with a business model that powered that, the ad tech, and now Zuckerberg has learned his lessons. I hope we have learned our lessons as well. So the question is, how do we get in a debate, in the design stage, in when this whole new ecosystem is developed? Matthew, do you want to have a first?
Yeah, I do have a number of questions about this, and I think that the big tech companies have already been burned once by the infrastructure issue that Michael was bringing up, and that was Google Glass. Does anyone remember that?
Yeah, absolutely.
So you had these nifty little glasses that filmed everything, and people were like, that doesn't sound right. You're filming everything, and who's getting consent for that? And lo and behold, what do we have? Just last year, we had Facebook launching Ray-Ban glasses, sunglasses. So exactly the same thing, and that's the augmented reality, which will feed into the metaverse. And so what he's worried about is that this could be a complete disaster for Facebook. It's a big bet on the future, and part of that bet is getting things right with the regulators. So we've already seen, as Michael pointed out, with ad tech, is that they just invented things as they went along, and from my point of view, they'll do the exact same thing with the metaverse. And so if you don't get ahead of the curve, and if you don't design from the ground up, we're going to be in an even worse situation, because just putting a couple questions out there. In terms of informed consent, do you have one administrator for the metaverse? Does that mean there's only one entity that collects all the personal data where you log in? So would it be like Gmail, where you just sign in and then you just say, well, I'm already signed in, so they can do whatever they want with my data? Or are there multiple places where you log in? If it's multiple, it's even more complicated, because what if the consent is different for each entity? So these things are, it's supposed to be a seamless environment, right?
Yeah.
Seamless and global. To me, that seems to be an impossible task. And then how do you give notice? Like, one thing, if you talk to anybody about GDPR, because people don't know the difference between GDPR and e-privacy, one of the reasons I said they hate GDPR is because of cookie banners. So what are we going to do in the metaverse? Have cookie banners everywhere? Where you're walking around the street in your nice nifty VR glasses, and then you see cookie banners everywhere, and you're supposed to be touching them and clicking them, and it's just insane. So if that's not sorted out now, then I don't want to go anywhere near the metaverse.
Cookie banners are illegal in themselves. That's the thing. They're an interpretive strategy to break the GDPR. They're not a requirement of the GDPR, which is So
one final point about that. The e-privacy directive, which we all know and love, has been with us for 20 years. So, and it's been proposed in 2017. It was meant to be in effect in 2018. It's now 2022. If that's the rate of change, if that's the speed, like Mr. Voss was saying, forget it. We're done. We might as well just forget about the metaverse, because there's no way anyone's going to innovate for the metaverse if they think, oh, maybe in 5 years or 10 years they'll have a regulation on consent. No.
Well, I think we need to think how regulators then interact with somebody or a group of companies that is starting a new ecosystem. And I know, Axel, with your AI Act, we have a regulatory sandbox. I know some of the supervisory DPAs have a regulatory sandbox, the ICO. I think they're sometimes just privacy. If you look at this type of ecosystems, you would want the competition authority to be there. Maybe if it's about banking, the banking authority. What were the ideas, or how do you see this going to work?
We have to think about at least how can we provide these quality data to a kind of a new dimension of data processing and so on. And here sandboxes might play a very important role, that we are not telling all our companies, please train your algorithms somewhere in the world, and then you might come back for this business. But this is not the way forward. We should really think about this model of Europe can provide values and technology, and both together then is kind of a better world. Yeah. So how to achieve this? So sandboxes might be a way forward, where we have these, let's say, environment protected and supervised and so on.
Well, you have a difference. I'm sorry, but you can have an innovation center where it's more free, but a regulatory sandbox is mostly not a completely free sandbox. It is. So,
please let me hope that the legislator is doing at the end something what is working also for the competition and the
exactly.
Yeah, but so far, what I'm more fearing here in this regard with the metaverse, this will at first the next disruption step, what we are into. We will do our business here, we will do our social life here, and so on. So we have to take this seriously in a way. But I do not want that all the criminals are meeting in metaverse, so that all the organized crime, the criminals itself to sell drugs, and also these sexual child abuse is taking place there. So this is, and therefore a future-orientated legislator should now, what you have mentioned, regulate it in a kind of a guidelines or whatever it is. If you are building something like this, respect these, and these, and thinking about how to control or oversight might be integrated into this. So this would be a way forward, but because this is coming, it's already there, not in this dimension he would like to have, probably, but this is coming, and we can't do anything about it. So that's why we should embrace the reality and then try to organize here something in our direction. And now it would be the time to do this.
Yeah.
I just think the European legislator is kind of schizophrenic on these things. That's probably not the right word to use, actually. But the reason I think is that on one hand, we need to find big platforms we can put responsibilities on. Could you design it this way? Could you design it this way? Could you actually pay for content moderation? Could you take this? And that's happening in Digital Services Act and similar. So that's a delegation, a deputization of the Metaverse Builder, a few of all these organizations. In practice, we see these are being organized to avoid liability, like if you look at ad tech or the way that Google manages its advertising system. Push the illegality out to the actors at the edge. We kind of keep it clean in the middle. On the other hand, we have an imagination that European AI is going to be like some European AI Mittelstand with lots of like plucky companies training with data sets they make, making cool things to sell on the market. No, these are captured in infrastructural dynamics that we're not dealing with and taking into account. And I think this is just completely magical thinking that is totally a disconnect with the way the technology industry functions. So if we want to get fundamental rights, but also have like a flatter, more horizontal digital world where people can do interesting things, start interesting companies, innovate in interesting ways, respect fundamental rights, have a trusted market, which actually people around the world say, we want to buy European things because we trust that place. We have to get to grips with the political economy of all of this. And for example, the AI Act simply copies legislation from the Low Voltage Directive in 1970s and puts it into the present day, the new approach. It's wild. Like, we need to get more creative and fast, and DPAs need to get more creative with their enforcement, because if they don't, they're going to be stuck in the quagmire of ecosystems, not knowing who to point at, like whack-a-mole, and subject to procedural challenges if they try to target ecosystems, which is what's happening right now around ad tech, and that should be the lesson we should take forward. Political economy. How does a DPA designed for data banks, regulating data banks, back in the 70s and 80s, regulate ecosystems that are designed to be slippery?
But also, I have
Anna?
I agree with Michael, but also, how do you investigate? If you don't have provisions for investigations, for information, for knowledge of what is actually happening and what the system is doing, how can you actually enforce anything and how can you regulate? I think that's, that I can't see that in the AI Act either.
No, well, I fully agree in the sense that you see sometimes a new technology being looked at in isolation, but they always work in an ecosystem, and that's why and we're given the complexities, that's why I'm saying, look, can you have one AI regulator? Can you have the privacy regulator looking at things? It's a kind of digital task force with all the elements looking together at a new ecosystem, and how are we going to organize that? Yeah? And the concern I have there is that I see, and I'm just curious what you think. I already said it, the Netherlands and Spain are appointing the DPAs as the supervisory authority for algorithms. And if you look at innovation just from a privacy perspective, while there's an AI race going on between, and AI is also used to I don't know, to exploit cyber, any system for weaknesses and exploit them in an automated way. I mean, we have AI needs in all types of sectors, and to have then the primary the authority with the primary head privacy looking and having to make those trade-offs, I wonder whether that is the way to go. And I don't know, who wants to go first? Well, maybe you, Axel. I mean, no, I'm serious, because I think the AI Act doesn't say you need the privacy authority. Look, AI is personal data, non-personal data. I think the DPAs are completely supervisory authority for anything with personal data. So if AI is trained with personal data, they have the hat. What do you think?
Yeah, the first problem I would say is that the legislator or the EU itself does not have a plan to construct the whole digital world or whatever. So, and the second problem is we are coming now in parallel with different legal initiatives like DMA, DSA, AI, and so on. Everyone is asking for an oversight. And so now we are confronting also, once again, our business with different authorities, and probably the data protection authority is looking differently on it than a DSA authority.
Absolutely.
On it, with the same data. And this is too confusing. So a solution, what we have a bit discussed already is, so in the discussion in the European Parliament is, do we want a kind of an AI agency or a kind of a digital agency, and or do we want to strengthen the national structures?
And with that you mean like sector regulators, like the banking and the health.
And now I would say it's time to think about, can we combine all of these, from the data protection authorities to AI authorities or oversight authorities? Can we combine these in a kind of an EU agency, however you're calling this?
Okay.
Might be a possible solution for it, so that you have all on board. What I'm missing if you are approaching these only by sector. So if you're just focusing on data protection, you're just focusing on data protection and not competition, cybersecurity, IPR, and so on. And this might then be a kind of a different oversight if you can balance everything a little bit better. And
I want to go to Anna, because I'm sure she has a, from a citizen perspective on that. I mean, would you expect a citizen to go, I have an issue with my doctor, I wonder whether the algorithm is right or wrong, or it starts with access mostly. Where do you go? To the health authority, to the AI authority, to the data protection authority? What would you, I mean, it's also Matthew.
I can give you a concrete example. The Information Commissioner in the UK has been doing regular surveys. I don't know if they've done some in the last years, but certainly in past years, testing how many people have heard about the ICO, the Data Protection Authority. And although the situation has improved over the years, you still have a substantial number, I can't remember the figures exactly, where people don't know what a DPA is. People have busy lives. When they have a concrete complaint or a problem, they need a gateway. They need somebody they are familiar to, whether it's their doctor or their consumer organization or whatever. They don't necessarily go to the authority instantly. So, having a centralized European agency would be impossible for citizens to address to. I heard Wojciech say earlier that, a possible model would be the one that we have in the DSA and DMA, where you have very big enterprises controlled centrally and the local ones, accessible to local people. As EDRI, we haven't discussed that or have a view on that, but, you know, it is a possibility, I suppose, but there are also a lot of questions is what principles do you have in place for the size of this enterprises that you control centrally, how many years it's going to take, what's going to happen in the meantime. And in the meantime, what we need to do is ensure cooperation, better cooperation between the different sectoral agency. And I can tell you in my many, many years experience in working in policy, I've seen a lot of turf fights. I haven't seen a lot of cooperation. Agencies tend to get, and it's because they're so overloaded with their own work and their own cases, they don't tend to think about horizontal issues and how to cooperate better. So I don't have an answer, but I think there is a problem that needs to be solved.
Matthew, any other questions you want to add?
Actually, I have a bunch, and we were speaking about notice and consent in the metaverse and ad tech, but just to put this out there for food for thought as we talk about who is in charge. So if we think about the metaverse and GDPR, for instance, GDPR has a very specific set of individual rights. So just to name a few, we have right to erasure, otherwise known as right to be forgotten, data minimization, right to access, data portability, right to object, data rectification. These are the fundamentals of GDPR written in. So that's okay for what we have today. But if you can imagine what would happen in the future, who would be responsible in the metaverse for guaranteeing each of those rights? I alluded to this like single login. Would that single login be responsible for it? But what if you're dealing with all these different entities? So that's one issue. Jurisdictional issues. We've spoken many times in the last couple of days about data flows, and what is the whole problem with that is who is in charge of the data and whether or not the GDPR actually applies. So in the metaverse, it's clear that if a entity is monitoring someone in the metaverse, then GDPR would apply. But how on earth would you figure out who's monitoring what if you're cruising around the metaverse and going over different jurisdictions? And the last one is special categorization of data. So that's Article 9. That's kind of the essence of the metaverse, because we're talking about very sensitive biometric data with your eye movement, your gait. You can actually I've seen studies where you can tell the person's go back to who exactly they are just by looking at the way they walk. Your avatar,
new forms of identifiers.
Exactly.
No
so all
doubt
that is, and how are we going to protect that?
Yeah.
So these are all questions that I had just looking at the metaverse and GDPR. If none of these are answered, then we're heading into real difficulty.
Yeah.
I have a two-sentence point.
Absolutely.
Which is just,
go ahead.
That's totally the wrong way to look at it. When we think of metaverse, which is a technology that doesn't exist, we want to ask, who do we want to be responsible in this case? Who do we want to actually fulfill these rights? If we say, let's wait for this thing to exist and then try and apply this sort of joint controllership framework and try to locate someone afterwards and figure it out, we'll get a terribly messy approach to this. Instead, and I think I completely agree with Axel here, we don't have a good vision of what we want digital society to be, and that's because it's not really political enough. We don't have parties sort of saying, what kind of digital society do we want? It's really hard to engage and describe that. It's a complex thing to do, right? But we have to engage in that project of in a world where we might be living more and more online and more connected even than today, what kind of balance of responsibilities do we want? And these are questions that seem quite niche and technical to us on this stage and in this room.
No.
We need to bring them forward into political debate. And politicians have to work out how to do that. Because if they don't, then I think we're going to get this fragmented world because there is no real vision behind it. There's no mandate.
Let's face it, those decisions need to be made in Parliament rather than every individual deciding yes or no.
I mean in an election. I mean they need to be part of the debate, political debate. In the moment, I think they're not. I think when people vote for Axel, they aren't voting for a clear vision because because they're the same with any party.
Where's your bullet list?
I think parties, when you read,
it's a good idea.
When you read, I think your probably national manifesto for your party, it doesn't actually lay out the real vision for the digital society in a clear way, as maybe we are discussing in this room. We don't get that debate.
New project for UCL.
Oh, what, to start a political party? No.
No.
A vision party.
There's no list. That's a project for society.
I'm checking on time because I'm supposed to have 5 minutes. So I think we need
questions.
It would be great to have 2 questions from the audience. So it's very difficult to see anything from here. So maybe the light can go on. I don't know. Oh, perfect.
Oh,
yes.
Someone at the back on the right, yeah.
So, anybody?
There's someone over there, the back waving.
Okay, somebody waving there, and I don't have a clue where the mic is, so. Yeah.
Hello, thank you for giving me the floor. My name is Jan Czarnocki. I'm writing PhD at K11 about legitimate interest and sensitive data. So my question would be, we talk about enforcement, but in this ideal enforcement world, do you really think, like in small countries, DPA, everyone's scared to say Irish DPA cooperates perfectly with our own Facebook headquarters? Do you really think that then still we'll not having this Instagram addiction of teens? Or maybe the problem is actually material with GDPR and risk-based approach, that having good arguments, you can get away with almost everything. You just put good arguments, and that's it, because you assess risk by yourself, and then you have some standards. But after all, like, you have these beautiful illusions like consent and purpose limitations that does not exist in practice, as your professor said, because of infrastructure, political economy, and how things work. So maybe we should actually have a courage and resolve to talk about modifying GDPR, because in my humble opinion, not talking about material things in GDPR is intellectual laziness. Thank you.
Well, I agree. It is not intellectual laziness. It is we're sidetracked by discussing all types of procedural things instead of discussing what the red tape should be for certain things. And Kat Sunstein said, look, autonomy, our rules are based on the idea that as long as you inform me about what you do with data, that I can make an informed decision. And Kat Sunstein says, look, autonomy is not deciding on everything. It is actually, if you have too much choice, it undermines your autonomy. And I find that now with GDPR, we passed a hot potato to individuals who find it very difficult to understand what is happening. So if you want to have a fair society, a new fair metaverse, we need to have a debate, discuss the regulators at the table with Facebook and all the others, and discuss how it should look like. And the question is, how do we get there? And that's why we have you, Alex. One comment here.
Yes, so at first I agree totally, because when we discussed GDPR, we never discussed AI and we never discussed metaverse. So that's why I think we need an update, modernization of the GDPR, but always, if it's coming from my mouth, my basher always are saying, oh no, he doesn't want to have data protection, and so they are ignoring this. They are not open-minded enough and thinking that there might be some problems that has to be solved. And this is what I also would like to go for it. Yeah. Yes.
Thank you very much. Another question. Yeah, there are many. What are we going to do?
Take them all, because I haven't got time. Should we take them all, because that's people?
So, okay.
Sorry.
I can't see it.
Do you want me There's three at the front in the
Yeah,
kind of this
there are
zone,
many,
so maybe they
but
can just take them one by one.
Can somebody
Someone
bring
come
the
down with a
mic?
mic to like the sort of middle.
Sorry.
Stand up, maybe you've got a question.
I'm here at the back.
Oh, okay, cool.
I can't see.
Sorry.
Oh.
So I'm afraid
Thought he
that
was from tech.
maybe the most concerning thing wasn't said in this room. Maybe the person who got closest to it was Michael. So Michael described this privacy by design that leads to slippery by design ecosystems. I totally support that view, that it's orchestrated to be slippery. But thinking back about the Snowden revelations of, you surveil my population, so I surveil your population, and we kind of trade data around there. I'm very worried about state actors getting into that act of leveraging slippery ecosystems with maybe something like, you influence my population, so I can influence yours. These types of dynamics. So I was wondering if anyone had anything to say about that. Maybe Michael, especially given the fact that one of the closest ecosystem that gets to this is the COVID tracking apps ecosystem. That was, many scholars in this room probably encouraged a privacy by design approach, but now we see that it's completely unaccountable by design. We have no way to really know how efficient or efficacious, how much efficacy there was in there or inefficacy. It's on device, we have no way of knowing, we don't have the actual data we need, and we don't even know that the web giants, the tech giants, are not collecting the data to improve their system.
Yeah. Thank you. Maybe we get a few more questions and then we'll see who answers it. But I get the question.
Thank you very much. My name is Bridget Cosgrave, and I'm here as a member of the board of directors of Sinch, a Swedish world leader. I just want to bring us back to the opening panel, where tragically we made the observation that we're operating with people on the other side of the table who have an ethic and moral vacuum. And so while I recommend, or I highly appreciate, Madam Moerel, your observations, having more discussions with these people will lead to nothing. That's what we have had as an experience thus far. So it's incumbent on all of us to be more creative and smarter to crack the nut.
One more.
Kai Rannenberg, Goethe University Frankfurt. So this is a question mainly probably to Axel, but maybe also to the rest of you. Axel, you argued that we should make sure that we don't lose the business because data protection doesn't feed by itself, and we should be more flexible when new technologies are coming in to protect and so on. This argumentation reminds me very much of a discussion and argumentation that I've seen in the car industry eco discussion about, let's say, 10 years ago, when it was about reducing emissions and all kind of that, and the point was, well, let the car industry decide on what kind of ways they reduce the emission and don't go into too much into detail with technology. And the result of that, especially for the German car industry, which was to be protected, was the so-called clean diesel and the corresponding scandal, which is, of course, much more an IT topic, because it was basically very much about fine-grained IT settings in certain designs of these engines. And so I'm asking you, is it really good to leave so much leeway when we see what kind of mechanisms can happen, even in leading industries, especially in leading industries? And isn't a bit more detailed control maybe necessary to avoid these kind of things? Because Volkswagen clearly doesn't profit from the whole situation. Volkswagen would have profited from, let's say, more openness in the middle management to report to the top. We have a problem instead of the situation that we have now.
Thank you. Let's try to tackle them. Axel, do you want to react to the last question? Now it's still fresh in your mind? Yeah? No, I mean, sometimes the whole statement.
I'm already so old that probably...
Yeah, something new, old wine and new, whatever you call it.
So what we are doing as a legislator is to give a kind of a structure in handling data in a legitimate way. If your intention is to deal illegally with them, then you can't hinder this with a kind of a GDPR. So then, of course, you need the data protection authorities to correct or to find a way, to find out what is going wrong. And here you can't really prevent from these scandals if these are intended. So that's why I still would say the authorities should more focus, so the data protection authorities should more focus or prioritize at the end their resources, because we do not have, and this is also one demanding I have, we need more resources for the data protection authorities, but also to be more service-orientated for all these upcoming business models that they are part, like this privacy by design. It's starting with them together, that we are not losing time, because speed is already a kind of a competition criteria. So you're having a lot of issues around all these data parts, but once again, you can't really hinder bad intention to do something. So that's why we need these authorities to check, to control, but also prioritize. It doesn't make sense if you're just looking to a small merchandiser or whatever, and just focus on the big ones at first, and then probably you might find also then the step down smaller ones, but I think this is necessary. Who can really harm our privacy, our data, then focus on them and not all the other little ones who have a kind of a good intention, but probably doing something wrong on the way of
and then
dealing.
Proactive, I think.
Yes.
So not wait till they did their work. So that is one of the answers. And I think you need to be open to discussions with the companies that build the new things. But the first question, I think, was very much for you.
Yeah, contact tracing apps. So it's a really key example, I think, of what I was saying, infrastructural power processing and so on. There's a system that arguably you can analyze it and not really easily find personal data at any stage in the system. It's very difficult because re-identifiability is so tricky at the different stages. There are a few attacks against them, but they're not, it's not obvious legally that there is personal data at any stage. So it's contested. But it asks the question of who gets to decide what code runs on the device. And I think it was Paul, because you're in the shadows at the top, so I can't really see. There is a big question about auditability, accountability in these confidential, not private, confidential infrastructures. So how do you build that in? Now, it is possible to assess. I don't agree that you can't assess efficacy. In England, efficacy was assessed in several studies, and it was a country that had a lot of uptake, 45% of all adults using this, and it was one of the only countries where it was integrated into the health system and averted several 100,000 deaths, according to cases, not deaths. About 10,000 deaths were averted according to statistical modeling. But it takes design and energy to do that assessment and accountability, and that wasn't done in many countries, and it does focus on need if these are being deployed, these big processing initiatives across the world, big processing infrastructures, design accountability in, that requires us to grapple with it. And the last thing I want to say, data protection might see these entities as a controller. So you might say in contact tracing apps, Apple and Google, by developing smartphones, are controllers, right? They're determining the means and purposes of processing. Is that a useful frame to govern these entities? Does it help us, and does it help data protection authorities actually vindicate rights? Maybe, maybe not, but I think it's a discussion we have to have.
Need to have.
It doesn't squeeze in.
We're wrapping up. You two both.
I just want to make, Michael's is brilliant at the technological insights. I want to make a more societal, democratic observation related to what the first gentleman said. We talk a lot about commercial surveillance, about the power of corporations and so on. We don't talk enough about what states are doing and how states are using the same technologies. The people who legislate, they put a lot of exceptions in the legislation. And we just had one workshop in this whole conference talking about, the vast databases managed by Europol, and the impact they have on the immigration community. There was a colleague talking about what's happening about the sort of child benefit scandal in the Netherlands. We don't talk enough about that, and because in a way we have we have the wolves in charge of the sheep. It's the public authorities that make legislation. And actually, long term, is going to have a very powerful democratic impact. And we need to talk more about that as well.
Thank you. Matthew,
Just two
closing
final
words. Up to you.
Two things just to reiterate what Michael just said about interoperability. And I think this is going to be key going forward, especially with anything dealing with the metaverse. So, okay, it doesn't exist right now. It's in the mind of Mark Zuckerberg and others, but we've seen what happens with monopolists. And if it's not constructed in an interoperable way, you know, again, huge problems, potential problems. So that needs to be designed from the ground up. And then, secondly, you know, thinking about this globally, all these EU regulations. One thing that is constantly mentioned to me by my 22-year-old son, who is interested in technology. He's like, how on earth can any of these regulations be designed when real experts aren't involved? People who actually are programmers, people who actually design algorithms, if they're not involved in working with the legislators, like expert groups, to say like, well, wait a second, you guys don't understand the technology. Maybe you don't even need an AI regulation. Maybe you're just completely going down the wrong path. That's something that should be seriously considered before we go off in a wrong direction.
Fair point. Thank you all so much. Thank you for your contributions in the prep. Well, we made a law, we can also change it. There are ecosystems out there that I think also need to be changed. I think we all need to be open for the future, and also there's no right and wrong, but a good debate is, I think, very helpful. So indeed, I heard many requests for a repeat in the next year. I can imagine Wojciech needs to build his budget after the drinks last night. So maybe 2 years. But we really hope to be back. Thank you all, and have a good trip home.
Well done. Well done.